So we'll have an English draft and make a very good interaction.
Are we okay for allowing to start now? So we do that at the end. When we're making the general comments. Yes. How's your timetable set with your timer?
Yeah, every speaker will have 20 minutes.
Okay.
Yeah, so they have
40 for each. Okay.
I believe, as per the bailiffs, I'm informed that each of the team members will actually have 20 minutes each. So it is your, at your opinion, and at your option, you can decide on how you divide the timing. So before you start your presentation, I think it's important if you can inform the bench on how you expect to divide the timing, and then you can proceed to your presentation. So the plaintiffs can start.
Thank you, my lord. With respect to time, we allocate 15 minutes for the main arguments and 5 minutes reserved for rebuttals and side rebuttals. And the same applies to the co-counsel.
I think that's a good thing for the team. The bailiff is telling me that the 40 minutes is excluding the 5 minutes for rebuttal. So do not use that in your presentation. So you have extra time to present. Huh? Proceed.
Thank you. Well, my lords, before you today, it's a case which has been emanating from a contractual relation between our client and the host state for an extraction, for an extraction of bilateral rights. And this said mining contract, the Little Mining Pact, has been in existence for over 30 years. And through these 30 years, a period of 30 years, there have been a series of change of leadership pattern, and which led to the reign of President Raven, whose reaction to the Little Mining Pact made the congratulation of our clients to be bitter. With respect to that, I'll be addressing on the preliminary objections, while my co-counsel will be addressing on the main issue. We would like to go and address the preliminary objections. With respect to the preliminary objections, there are 2 issues which has been raised. The first being on the admissibility and jurisdiction, and the second being on the group standing of the second plaintiff. With respect to that, on the first issue, with respect to the jurisdiction, my lords, the plaintiffs are not disputing that the Little Mining Pact did not contain the arbitration clause. We do not dispute that fact, but so long as the right to arbitration is a contractual right, and the acts of the defendants amounted to their waiver to this contractual right. So long as this Arbitration Act, it is valid, we do not argue with the validity of it, but what we argue is that the right to arbitration, as it is a contractual right, the defendants acted as the waiver to their right. With respect to that, I would like to say that the first act of the defendants is that they refused, when approached by our client, they refused to go to arbitration. And the same could be seen or could be observed in the case record under paragraph 22, where the CEO of the companies shifted from one jurisdiction to another just to try to solve the matter amicably. Furthermore, they went further to file the notice of arbitration, and the same was neglected, or the same was refused by the defendants. That being the case, they waived the right to arbitration by the act of refusing to solve the matter amicably, then went to arbitration. To submit that this court has jurisdiction to hear and determine the matter.
Counsel, with what your arguments on the preliminary objection, but what are the legal authorities for your grounds? Which law says that such non-appearance for arbitration or such non-appearance for amicable settlement automatically waives their right?
Thank you, my lord. I would like to draw this court's attention to Article 25. Proceeding, I would like to draw this court's attention to Section 13 of the Arbitration Act, which, together with the case of motor service and others, which has never seen, the court of the view that whenever in a contract there is an arbitration agreement and a party has failed a proper remedy or a proper procedure is to file a petition for stay of proceeding instead of filing the written statement of defense. And the effect of filing the written statement of defense amounts to a waiver of the right to arbitration, hence agreeing to the court's jurisdiction.
Counsel, in the exit rules that you have just mentioned,
Yes, ma'am.
are there options or are there ways forward to proceed when one party does not submit to arbitration? That's one. Two, on the issue of filing a WSD, the defendants filed a WSD with preliminary points of objection, objecting the jurisdiction of this court. In that regard, does your argument that filing a WSD still stand, that filing a WSD means that the defendant accepted the jurisdiction of the court? Does that argument still stand in light of the fact that there is a preliminary objection on jurisdiction?
Thank you, my lord, with respect to the questions. First, with respect to the first question, I would like to ask this court to give me time to refresh. And with respect to the second, I'll say that to the provision that I've cited, Article 13 of the Arbitration Act, and the case that I've cited earlier, what has been provided in the provision in the case is that whenever the WSD has been filed, so long as it is a WSD, the same waives the right. What was to be done by the defendants was to file a petition for the stay of proceeding. That was what to be done, and not filing the WSD.
And counsel, I've seen you citing the Arbitration Act.
Yes,
which Arbitration Act is this? Can you give us a full citation of it?
Well, it is the Arbitration Act of California of it is the Act of 2020.
Okay, just to be very specific. You have read your facts very well.
Yes, my lord.
What are the laws applicable when it comes to construing the contract, the present contract which is in question before this court?
Thank you, my lords. We'll not dispute that in the facts it is provided that the legal mining pact is governed by the laws of another jurisdiction. But with respect to that, my lords, I would like to draw this court's attention to the Lexifori doctrine, which is provided in the doctrines of private international law, which hold that whenever parties have agreed to the forum and the choice of law, the same should go together. The Defendants Act of waiving their right to arbitration could be, we argue that the same amounted to the waiving of the of the governing law that they chose. So we would like to direct this court with this court that the law that should be applicable should be the laws of Gatronia, because they waived the right to arbitration and the choice of law that they chose. Thank you, my lord. With respect to the second issue on locus standi of the second plaintiff, we'd like to hold that the second plaintiff indeed has locus standi because, one, they have cause of action, and two, they have sufficient interest with respect to this suit. On the first issue, on the first sub-issue to my preliminary objection, I would like to say that we say that the second plaintiff was a subsidiary company to the main company, and its incorporation. To the execution of the illegal mining part. And with respect to that, I would like to draw this court's attention to paragraph 13 of the Moot problem, where it is provided that the three countries, the countries where they were trying to establish or to incorporate this company, they agreed that we cannot conduct the mining activities unless there must be a subsidiary company which should get a certificate of compliance in the Republic of California.
Counsel, sorry, just to take you back a little bit. You have argued before this court that the law applicable should be the law of Gatronia.
Yes,
so I would like to ask you, in respect to the law of Gatronia, what are the procedures of suing the government?
My lord,
and have you followed those procedures?
Thank you, my lord, for the question. With respect to that, under the Government Proceedings Act, we not argue that Section 6 sub 2 of the Government Proceedings Act argues that a notice of 90 days should be filed to the government while being sued. And I'd like to draw this court's attention to the case of Alois Chacha versus Winter Chacha, where the High Court of Gatronia was of the view that the purpose of having the notice to sue, it was for the government to prepare itself and to see whether it can solve the matter amicably. My lord, I'd like to draw this court's attention to paragraph 22 of the Moot problem, where it is seen that our clients approached the government of Gatronia by filing a notice to take the matter to arbitration. And that being the case, so long as the matter has been attained, that to make the government not to be taken under surprise, the notice that was served had sufficient notice that they are intending to be sued. And that
so, counsel, are you trying to say that factual analysis or whatever fact you're trying to assert eliminated the legal requirement, a procedural requirement under the law?
Well, my lords, it's not that it eliminated, but like we humbly pray this court to hold that the same could be taken as an alternative to the notice, and we pray for the declaration of this court that under that notice which has been served should serve the same purpose, because we don't intend to take with that, I'd like to abandon that issue, that argument, and I'd like to go with the same question. I'd like to say that our clients suffered irreparable loss. And with respect to the irreparable loss, the stocks of the companies dropped behind. And with the dropping, it is the view of the plaintiffs that we could not wait for the 90 days to expire, because the stock would have further dropped. So
that waived the legal requirement of filing a notice.
It's not that we waived the legal requirement, my lord, but we play this court for the declaratory order that it needed urgency for us to file this, because our clients suffered irreparable loss.
Weren't you supposed to bring in a special application requesting for the right to be heard and the waiver of the requirement to serve a 90 days notice to the government,
Well, my Lord,
according to the laws of Gratonia?
thank you, my Lord. With respect to that, I earlier cited the notice to take the matter to arbitration. It had the same content that they cannot be taken under surprise. So they had prior knowledge and notified them in that notice. Well, thank you, my Lord. With respect to that, I'd like to submit that the second plaintiff has Okusistani, and this honorable court should overrule the preliminary objections which has been filed by the defendants. Thank you, my Lord.
Okay, now you can proceed to your main submissions.
Well, thank you, my Lord. As I said earlier, that I'll be addressing the preliminary objections, and my co-counsel will then proceed with the main arguments.
Thank you, Lord. Well, as introduced earlier, my name is Hilary Kweka, presenting the main issues on merit on behalf of the plaintiffs. Well, Your Honor, begin with the first issue that the Honorable President of Gratonia has reached the real mining pact we submit as follows. Well, Your Honor, to begin with, the President has, through his actions, unilaterally attempted to terminate the contract. And this is contrary to Article 11 of the Pact, which forbids unilateral termination of the contract. Your Honor, through the revocation of the granted right of occupancy to the 300 acres that was initially granted to the plaintiffs, and leaving it with the 200 acres, which is already exhausted, that is constructive termination of the agreement due to the deprivation of all the economic benefits and gains that could be realized by the plaintiffs. Your Honor, if I may submit before this case, before this court, unilateral termination, Your Honor, does not have to be open. The very fact that the President, through his action, revoking this right to the land by depriving its beneficial capacity to the mining company is, though not explicit, though not open, still amounts to unilateral termination. As, Your Honor, though not binding in this court, please be persuaded by this foreign decision in Metatran Corporation versus United Mexican Oil that constructive termination also is termination of the contract.
Counsel,
Yes, Your
which
Honor.
case have you cited again?
Metatran Corporation versus United Mexican States.
Can you report it appropriately?
Yes, Your Honor. Your Honor, it is an exit decision of 1997.
I beg your pardon?
It is a decision by the International Center for Investment, for the settlement of investment schemes. Your Honor, we seek this court to be persuaded by this decision.
Proceed.
Counsel,
Yes, Your Honor.
you're claiming that the President unilaterally terminated this contract through his actions,
Yes.
the President of Gratonia. But if you refer to paragraph 18 of the facts of this case, we see that your company was reporting losses while your parent company was reporting profits, and the sole source of income of the parent company is Gratonites, and Gratonites can only be found in Gratonia. So in that sense, wouldn't you agree with me that it was you who initially unilaterally terminated this contract by avoiding to pay taxes in Gratonia?
Thank you, my lord. Well, my lord, though that is indeed in the case file, Your Honor, that has not been decided in any tribunal or case on that affairs.
No, I'm not speaking about a case, I'm speaking about the actions, yeah? You went in to do business in Gratonia, you said you would pay taxes, but then the company, the local company, is not paying taxes, is reporting losses, while the parent company is reporting profits, and the only business that the parent company does is Gratonites, which you mine in Gratonia. Obviously, doesn't this mean that you are actually making profits and you're just not paying your taxes? And if that is the case, didn't you initially breach this contract with Gratonia?
Thank you, Your Honor. Your Honor, may I bring this court's attention that the laws in Danzig, specifically its on tax administration, are different from those of Gratonia. My Lord, taxation laws in Danzig are, Danzig's a tax haven. Its rates of taxation are relatively lower than those of Gratonia. My Lordship, rights were being prejudiced. Article 9 of the Legal Act allows it to variate the contract, to vary the contract.
So when you breach the contract, they should variate it. But when they breach the contract, you sue them.
No, Your Honor. We actually did not breach the contract because we haven't broken any law. Insofar as the person that we have not decided to have broken any law, just a mere part of the chief executive, Your Honor. And abiding the checks and balances principle, what the president says is not exactly what the law says. A court should have said what the president is saying. Thank you. Well, further, Your Honor, Article 7 of the Legal Mining Act provides for confidentiality clause. This is saying, my lordships, that the contents of the legal act are not to be disclosed unnecessarily to the general public. Well, Your Honor, in violation of this article, the President, in his official address to the citizens of Gratonia, as evidenced in paragraph 22 of the case file, he hinted that the legal mining act has unquestionable terms. Your Honor, that is in relation to the
Counsel, who are the parties to the Little Mining Pact? Yes, who are the parties?
It is the Jones Mining Company and the Jones Gratonia Mining Company and Gratonia.
Gatronia. Who is Gatronia? Isn't it the people who have the right to be informed of whatsoever is happening by their government as well?
Thank you. Your Honor, it is the people and they are happy. Your Honor, that right is not absolute because it is the government that holds in trust on behalf of those citizens to contract and had the capacity to contract and not the general public. Your Honor, if you may agree with me, it is not practical that all citizens of Gratonia could participate in the signing of this pact.
What the signature part is can be representative as well, but with regard to the information on what is happening on the contract, things that would affect the real participant of the contract, don't you see that it was rightful for the President to inform the public?
Your Honor, my clients, being a private company, my lordships, Gratonia had consented, had not disputed the inclusion of this clause as it should have done in the negotiation of this agreement. So they were fully aware of what.
Counsel, does the clause not have an exception?
The clause, my lordships, has an exception.
What is the exception?
Again, relying on the valuation clause, they should have indirectly notified and requested my clients to vary that contract, but that provision.
What is the exception of the confidentiality clause? You may.
My lordship, while I'm still thinking about that, we proceed with other issues. I come back.
Proceed.
Further, my lordship, I'd like to submit before this case that the President of Tanzania has grossly breached the arbitration clause in the contract. My lordships, Article 12 of the Legal Mining Act gives jurisdiction to the International Center for Investment International Center for Settlement of Investment Disputes jurisdiction and bars Caledonian courts to decide on matters that on the disputes likely to arise in the current contract. My Lordships, contrary to this argument, the defendants went served with the notice of arbitration for them to attend before the exit, they refused. That is in violation of as stated earlier, the Lordship of Article 12 of the Legal Mining Act. Your Honor, I this court's attention to Article 25 of the Exit Convention. Your Honor, the withdrawal of consent to accept the jurisdiction of tribunal is not lawful. It is not allowed, so long as the party had initially consented and is member to the current convention. So,
Counsel, I'm glad you brought this up because I asked your fellow counsel, and since you've brought it up, maybe you can answer me. Since they did not tender an appearance to arbitration, what do these rules that you're citing say? What are the options for you as the party who appeared in a case where one party does not appear in arbitration? How does that arbitration proceeding continue? How does it proceed?
Well, thank you, Lordships. The arbitration proceeding cannot actually proceed without the involvement of the other party. And that is why we are seeking, we are invoking the jurisdiction of the current Caledonian Commercial Division to actually help us with the matter.
Counsel, are you aware of the principle of exhaustion of local remedies?
Yes, Your Honor, I was about to proceed.
Okay, proceed.
Your Honor, due to the failure of compliance with the notice of arbitration, it has been the position and it is actually being executed by the plaintiffs that it should actually exhaust all local, administrative, and legal remedies. Your Honor, Persons Paragraph 22, we have attempted to amicably settle the matter without any success.
No, Counsel, you are misdirecting the questions. My question was actually an addition to what Her Ladyship Judge asked you. Now, you are supposed to answer in that line. Don't take us to the administrative. We are talking about the remedies available under the exit itself, okay? And when we talk of exhaustion of remedies, that means you have to exhaust all remedies available within that particular forum. That is the question. Can you address yourself on what is the available procedure under exit and whether you have exhausted it?
Well, Your Honor, I think that is the issue that you presented and this calls attention to Article 6 of the Exit Convention that requires us to exhaust all below remedies. It is why it had been a resolution of the plaintiffs to submit a matter before the Commercial Division of government.
What we are trying to say is, you filed for arbitration at ICSID. The government didn't appear. Was the solution for you to come and appear to this court? What do the ICSID rules say that once one party doesn't appear, what next? Does it guide you to just leave? What does it guide you to do? This is the second question you have reserved. Proceed.
Further, Lordships, as it is in the habit of the Honorable President of the Legal Mining Act, the President subjected the Legal Mining Act to a negotiation. Lordship, this is through the application of the Permanent Sovereignty Green Registration of National Dams Act that was enacted in 2017. That is post the conclusion of the Legal Mining Act. My Lordships, the Legal Mining Act and Article 10 provides stabilization that prevents the